You don't see that as much as you used to when I first started practicing, and when we first started adopting the Tennessee Administrative Office of Court started adopting these specific procedural forms for orders of protection. But you used to see people still trying to go under Rule 65 or Rule 6507 to get what is really an order of protection. That's not correct. An order of protection is its own cause of action. Even though we file it within our family law cases, it technically is its own cause of action. It technically gets tracked separately and differently than our other orders that are issued in our civil cases. So there's a lot of differences. The restraining order does not have the ability to put the protection, those kind of boilerplate language, the firearms restrictions. Your civil judge doesn't really have the authority outside of the order of protection to place those restrictions on an individual in a case. Those exist specifically for this quasi-criminal proceeding. So under Haslam, we did see a change that allowed alleged victims to bypass the standard 21 days that they had to wait in order to get a handgun. We got a lot of changes to these laws, period, to be honest. But anyway, they don't, if there was any waiting period, an alleged victim doesn't have to wait. The order of protection serves as a temporary carry permit the minute it is issued. That's even if it's ex parte. And then there is, an allowance or a provision that allows the dispossession of firearms, but I would tell you, just to make sure your client is aware, there's not a lot of teeth to that. There was something before the legislator a couple of years ago, I think it was 2020. It did not pass, it's been tabled, but I don't want to get into all the details of that, but it basically was going to allow there to be some more teeth. Right now all you have is, hey, do you have any firearms? Yes or no. I mean, they have to sign an affidavit saying that. Make sure you insist upon that if you're representing a victim and they claim the person has them, so at least you can get contempt of court, or you can get something else later if you prove that wasn't true, because sometimes that piece doesn't get done. They're supposed to fill out an affidavit that either says yes or no, I have them, and says here's what they are, list them specifically, and then they're supposed to be dispossessed. There was a law that was going to allow law enforcement to come in and physically remove those, and if there was an alleged violation because of possession of a firearm, that they would be able to do a sweep on that basis. That didn't pass, so all you have now is the affidavit, but I would insist on it being signed off on so that you have some avenue for your client in the future if they are lying or they don't dispossess of all their firearms. I do want to touch on something else here. Under the statute, although they're not going to be as comfortable in 201 handling these types of issues, the statute does give them the authority, even though it's outside their standard wheelhouse. And so if you're dealing with somebody who doesn't have a divorce and would have to navigate all the multi-steps that are usually required to get certain types of relief in juvenile court, they can go ahead and rule on the issues of temporary support and parenting time. Not such a big deal in Tennessee where if you have the mother, for instance, it could be an issue if you have the father, though. What if the mother is the aggressor? Under Tennessee, they're not married. Under Tennessee law, she has all custody, according to statute, and he needs this court to now say, this child needs to be given to me, and we're not getting a divorce. There's not any other family action pending, but I'm going to need the custody of the child, and I'm going to need support to be paid to me while this order of protection is in place. They do have the authority under the statute to issue a ruling, because the statutes were devised to prevent piecemeal rulings and the need for piecemeal relief throughout all these different courts. So that might not happen frequently, but if it happens, just know that you can proceed and should be able to proceed, although you might have to massage and argue and really point it out why judicial efficiency has to be served that way. The newest thing that I can think of is the cell phone splitting, is the directive to a cell phone provider, whether it be Verizon, AT&T, or whoever the cell phone provider is, to split a bill. And so that's something you can only get with an order of protection. I think the thing I could compare it to kind of give you an idea or give you a point of reference is Maximus, or anybody who is enforcing child support laws, has a very different toolkit given to them under the law than we do as private practitioners when we're trying to secure child support. We don't have the ability to intercept somebody's tax return, take away their CDL, and other enforcement tools that have been specifically given to an organization like Maximus, really because they're acting on behalf of the state. So similar to to restraining order, the civil judge really doesn't have the authority to restrain certain constitutionally protected rights, and definitely not to give a directive to a cell phone provider to split the bill. So what I'm talking about there is if you get an order of protection and you represent the victim, you have the ability to request that the court also issue an order, there's a special form for it, to the cell phone provider to split your client's bill. And this doesn't mean where your client will get a separate bill and have to pay it, but to remove your client's activity from the family plan bill so that they cannot be stalked or tracked. Their calls can't be stalked or tracked, who they're texting can't be stalked or tracked through the cell phone provider. So you can ask them to do that, and that just means the bill stays the same. The same person who is paying it should be paying it, but the number for your client no longer appears on the bill. Now, cell phone providers are still somewhat new to it, and you might have to do some what I would call massaging to get it done correctly, but you are entitled to that with an order of protection, not a restraining order. The order of protection also is going to be reported differently, and this is why you might have a client, you might even still look at 65.07 or Rule 65 as an option, and you need to be able to explain that to a client, because there is going to be a reporting obligation once they have an order of protection. Now we're talking about a fully adjudicated order of protection, not necessarily an ex parte, but that is going to be able to be put into the national reporting system, and it's required to be put into the national reporting system so that it can get full faith and credit enforcement if they go across state lines. If they were on vacation and that person was stalking them in Florida, the order of protection you got for them in Tennessee should have the same ability to be enforced in the state of Florida if they show it to local law enforcement or whoever they need to show it to. Your restraining order does not have the ability to do that. Your judge in your civil case does not have the ability to tell other states what they are going to do. So your client still may have some reasons that they would prefer Rule 65 relief other than, an order of protection. And some obvious reasons I can think of would be if their spouse is in a profession, their spouse is the primary provider, and in a profession where they believe there is a zero tolerance and that the order of protection will absolutely impact their employability. And if it does, that means there's no money for the family. So your client may still want Rule 65 protection, although I would advise you to give them a very specific letter if they opt to go with Rule 65 relief instead of an order of protection, so that it's very clear in some type of communication, written communication to them, that they understand the limitations of Rule 65 or restraining order relief versus an order of protection.